And I'll hand the mic over to Melissa to take charge of this conversation. Over to you, Melissa.
Thanks, Terence. Assalamualaikum. Hello. Good morning, everyone. I see you're leaving. Come back. We're about to start. Come back and stay with us and power through the coffee break because we're about to start and it's going to be an interesting conversation, I promise. Very quickly, I'm just going to introduce myself once again. My name's Melissa Idris. I am an anchor and lead editor at Astro Awani News Network, where I host a couple of talk shows. On weeknights, I host a political talk show called Consider This. And on Sunday nights, I host a show called The Future is Female, where I speak to incredible women about the change that they are creating in the world. But on the side, I get to moderate wonderful panels like this, and I'm very grateful that you have invited me to be part of this wonderful event. So this panel today is going to be intellectual property in the realm of artificial intelligence. And of course, as we know, the discourse at iNation in the past couple of days has shown us that AI is really not just a tool anymore, it's a collaborator. It's a co-creator in how we create art and music and inventions. And of course, that comes with difficult questions. It raises the fact that we need to ask who owns these creations, how do we protect these new forms of intellectual property, and what role does technology like blockchain play in influencing or managing, interacting with AI frameworks. So I would like you, during this next 45 minutes or so, to think about this. If the very idea of inventorship is changing, then how do we ensure that our IP systems are evolving as our creativity evolves? So we're fortunate to have a wonderful panel today, 3 distinguished panelists who bring a wealth of insights and expertise in industry, in academia, and in government. So allow me to introduce Dinis Guarda, who is the founder and CEO of Ztudium. I'm sure you're all very familiar with Dinis from his session this morning. But on this panel, his insights into how AI interacts with IP frameworks will be very crucial. So we're glad to have you on the panel with us, Dinis. We have Biruntha Mooruthi, who is a technology transfer and IP specialist with over 20 years experience. So with her work at Uniten, she's an advisor at Uniten, and working in that triple helix of government and academia and industry, that really she can lend some insight into how the ecosystem needs to evolve going forward. I also have Syaufiq, Abdul Latif, who is the legal officer at MyIPO. He's here. He's also currently the Secretary of the Copyright Tribunal of Malaysia. There you go. All right, so wonderful panel, and I would love for you to be part of this conversation too. We've got mics on the side. Think about some of the questions that may be in your mind or that may be triggered through this conversation. All right, so we've got about 45 minutes. I'm going to kick things off. Dinis, with a question to you from the very end. So let's start broad. Let's start with looking at how the challenges, what you see in terms of the challenges. What are the biggest challenges AI poses to traditional IP frameworks, particularly if we look at the context of establishing clear ownership of AI-generated works?
Yeah, it's a big question.
It is. We'll start big.
I've been working with a couple of researchers on this area, and from the multiple universities worldwide, and for instance, even the World IP Organization in Switzerland. And one of the things I think it's important just to set up the boundaries you ask in terms of main considerations is, first of all, at the moment we are in a bridge where what is human, what is AI. And I think the challenge right now is there's a lot of AIs already getting into AGI level, and it's another big question, but it's not the focus in this conversation. So IP, so first of all, is a fragmented global ecosystem. And for instance, if I'm here in Malaysia, I'll have to trademark or create an IP or patent something looking at the regulation of the country. If I do it in a global level, it becomes much more complex. And at the moment, there's as well an hybridization because, for instance, most of the the code that we're going to have in the next 1-2 years is going to be, so for instance, anything we do in terms of software development is going to be done with AIs. So that means around 60 to 70% will be API-driven technology. And then how we put these APIs, and I will try not to go too technical, but I think we have quite a technical audience, is how these APIs are going to be talking with each other and how your company or your startup or your government can actually pick this and protect the intellectual property on this. So this is a big challenge. For instance, I'm building a lot of AI systems, and one of the things is how you protect it public. For instance, if you do a paper, for instance, most of the big corporations like OpenAI, Anthropomorphic, and the list goes on, they actually release papers, even Google and Microsoft, before they do something. For instance, I interviewed recently the global head of research of Microsoft, and everything they do is paper-driven. So that's one thing that starts, and this is from top level, Microsoft's, NVIDIA, the quantity of papers, patents, for instance, the Apple, everything is driven by papers and research. So that's a big component of academia research mixed with the way we take the IP into our business. Of course, the challenge if you are a startup is how can you protect yourself? So I think the answer to that, because I know that we are driving an event for startups and innovation, is having a strong digital presence. It's a very simple first step. For instance, it might be even your personal data or your personal IP in LinkedIn and things like that. Just make sure that you trademark, because for instance, the quantity of IP scams that are going to happen is going to be, I don't want to open in a Pandora box, but I think these are some of the biggest things. But then one thing as well, and this was an interview that I did in my YouTube channel that I loved the interview because it was with one of the biggest researchers in IP in the world. He's a professor from UCLA and Surrey University and Columbia. And one of the things he mentioned is, actually his book is an AI, an author. And I want to finish with another thing. You mentioned the creative industries. I work with a couple of Hollywood people, and I'm involved with a couple of discussions. For instance, one of the challenges right now, I'll give you an example. For instance, mainstream artists, I'm talking global playouts. For instance, if you do a video just 1 year ago, a video normally for a mainstream artist, I'm not going to mention names, although I work with some, would be like $500,000 minimum dollars for a video in YouTube. Then another $500,000 for promotion minimum. And I'm talking, this is, of course, I'm talking the top part. All these budgets right now are cut in 90% with AI. So this is disrupting not small startups, it's disrupting big things. And for instance, governments as well. For instance, most of the IP AI creation in the world is actually in the US and China. So it's a lot of considerations that we have to do, and of course Malaysia is quite fantastic geolocated because it has Southeast Asia, it has the Islamic world, so it actually reached 2 billion people, and it's actually probably the most stable country of all these countries. So I think there's a lot of opportunities in the context of Malaysia, the challenge we know, and they're going to be bigger.
Okay, I think Dinis has wonderfully set the scene. I think you pointed out to a number of key points that we will try to explore during our conversation. But I want to bring Biruntha into the conversation. Because you work at the intersection of research and commercialization, what did you make of what Dinis said in terms of challenges? When we think of commercialization or bringing something to market in the age of AI, how do we redefine inventorship? Has Malaysia got it quite right?
Yes. Thanks, Melissa, for the question, and a very good morning to everyone. As we know, definitely AI is basically transforming the innovation landscape in Malaysia, and it's very important for us to basically look into how can we leverage from all these technologies, research outputs, and solutions that companies are developing. There are so many advocacies, initiatives from the government in terms of pushing the digital transformation, digital economy. But at the same time, we should capitalize from the creations of work that we're doing in terms of the IP economy. So it's very important to align the digital economy and IP economy, and to basically give that platform for startups, SMEs, researchers, for various stakeholders, even government policy makers, to see how can IP play a vital role in terms of capitalizing the AI technologies and solutions. So it is very fundamental, first of all, to understand the definitions of IP and the various components of IP that sits within an AI business or an organization. So in this case, do we understand the concept of intellectual assets, intellectual capital, and also intellectual property? And how can we smartly strategize these components within an organization or a business of AI to basically look into commercializing the outputs or AI solutions that we are creating? So we are talking about global expansion, cross-border collaboration, but without this component embedded in your company's strategy or in the policies that we are developing, then it's, we can't go too far. And in terms of inventorship, so there are three main challenges. So just to basically make this simple, number one is we have to look into the legality, so the legal personhood. So in terms of AI, the traditional law of IP, it recognizes human creation or human intervention in terms of the development of technologies that we are developing. So the challenge here in the realm of AI, when it comes to IP, how can an AI or a system or a technology, or in this case, AI is also known as an agent. It's a very intelligent agent. But how can we give inventorship? Because that now goes to the next question, which is the accountability and liability. So let's just say we are going to give inventorship to an AI. What about infringements later on? So that is why engines like GPT, when we are cleverly copying the text, they said, we are not going to hold the copyright. It's not to us. So that is another aspect of challenges when it comes to inventorship. And then, of course, morally and ethically. So the IP law definitely honors the human values, the creation, the credibility that we are putting into the work that we are developing. So we don't want, or the law doesn't want, to diminish the value of human intervention or the creation that we are developing. So there should be so these are the challenges. And there, in terms of redefining inventorship, so this is where I guess stakeholders like MyIPO, WIPO, government agencies, reputable agencies that are looking into digital economy, IP economy, the various strategies to look into redefining inventorship to see the degree of human intervention in it, and also how can the output of the systems can be looked into. So for example, I know all of you would have heard about the Davos case, which stands for a device for the autonomous bootstrapping unified sentience. So this intelligent system, or it's an AI solution, it actually mimics the human mind. So it's made out of a neural network that develops various IP. So you don't need human to create. It creates new products and outputs. So when this Dr. Steller, he wanted to basically file this creation. So there was two products. One was a beverage with a very innovative grip of this technology, which was developed not by Steller, but the system or the agent that he created called Davos, and also another device called, it's for a fire emergency alert device. So he wanted to file a patent on these two technologies, but guess what? The English court at that time did not recognize. So this is because they said, how can we recognize the system has an inventor? So this has been a very, it has set a debate, all right? It's a scene for regulators to now look into how can we now redefine this inventorship. Yes. So, I guess a lot of debates are going on, and I think maybe MyIPO will be in a better position to see where we are going in terms of reforming that inventorship, the legality part of AI.
Well, this is where we bring in MyIPO and particularly a legal practitioner. So let's talk about that, Syaufiq. When we look at Malaysia's current IP laws, how does it interact with AI-generated inventions? Talking about what, following up on what Biruntha mentioned about the challenges in terms of the legality of it recognizing or prioritizing human invention.
Okay, thank you very much. Let me set up a scene. AI is not just a tool. Nowadays he claims to be an inventor or creator. When we talk about AI-generated work, or we call it the generative AI, we talk about these two components, patents and copyright. Patents produce an invention. Copyright produce a work. I mean, in Malay, we call it a karya. So when someone created a work, I mean an inventor in terms of patents and also copyright, we call it an author, for sure they want to actually protect their works against any unauthorized use. So the questions here, when the IP laws being created during the 1980s, when the first Berne Convention, the TRIPS agreement has been enacted, the IP laws are created during that physical time. So we are moving towards the digital, and we are moving towards now to the AI system. So when the creators or an author has created a work, they are expected something in return, that if someone wants to actually use my work, you have to pay me and in the form of royalties. When it comes to the AI, or during this AI, the most important thing that we need to look is the misuse or unauthorized use of someone's work being trained into the AI model itself. Most of the AI models, I mean not limited to the Dr. Stephen Taylor case, in case of Dabus, there is a lot of cases going on in the world. For instance, in the UK, Getty Images, one of the company, has been sued for using someone else's work without permission. They are using their data being trained for AI. That's one example in the UK. We could see in China where someone used an artistic work or Ultraman being put into the AI system and produce an output which resembles the picture of Ultraman. Let's say we go to the US. There is a bundle of cases. OpenAI has been sued by the New York Times company because they use some of the portions of the journals in the news, been trained into the AI system and created a new work. Not only that, some of the music companies, I mean, most of them are creators and innovators, where they are taking AI companies to the court because they are misuse or using their data without permission. So, in this sense, in Malaysia, if you want to talk about AI, who actually owns the AI works? I mean, in terms of the generative AI. Let's say A created a work. A is a user, he doesn't own anything. So he put that work into the AI models, create an output out of it, then let's say they come to MyIPO to register their AI invention or AI work. So the first question that we need to ask is there is an originality over the work that's been created because it is being assisted by AI. Even you want to register under the AI name, for instance, for the Dabus case, it surely cannot because most of the global jurisdiction prohibited if you want to register AI output under the machine's name because machine don't have any human contribution unless you want to register it under someone as a developer, a company, and so on. So that's the global issues which currently left untouched where there is no court judgment which give whether the inventor, whether the AI can be the inventor itself or we must attach those attributions to the human. I think more or less we are talking about this kind of blur between what can be protected and what cannot be protected in the era of AI.
Yeah. Dinis, I saw you nodding along. Does this resonate? Are these problems clearly global problems today? But what do we risk if we continue down this path of, making that differentiator between what is AI generated, what is human collaboration? How do we think this through? This is clearly a global problem that all governments are having to deal with.
Well, I think it starts with us personal, because, for instance, right now we're giving all our data to AIs. So, for instance, you mentioned the lawsuits. Perplexity.ai just was, like 3 major lawsuits because they integrated a lot of their data in the LLMs. And this is a bigger challenge right now. Is, for instance, I give you an example. For instance, we're working building a lot of LLMs ourselves, and there's an ethical consideration and an IP consideration. Because, for instance, I can just pick all the data of Malaysia and create a Malaysia LLM. No one will stop me. That means I will have more power in terms of data than all the government of Malaysia. If I have enough GPU computing capacity, it's quite straightforward. And trust me, major Silicon Valley guys are doing it. So the challenge is that there's a level of IP, a level of economical considerations, and a level of ethic considerations. Because one thing is what is public, the other thing is what is not public. And as well, like you mentioned, for instance, at the moment, MyIPO and most of the international IP organizations don't consider that an AI is an IP. But effectively, like I mentioned in the previous talk, there's already 1 trillion AI agents out there, and we're going to have around 50 trillion in the next 10 years. Trillion, okay, is more than all the humans. And all of these AIs have more intellectual machine computing than all of us. All of us combined, okay? Even one of them can combine all of us. So don't underestimate this. So I think there's one first part, and I always try to be very civic on this and activist in the sense that it starts with our own data. So whatever we put in ChatGPT or Claude or Perplexity.ai, we have to reverse engineer because it knows everything. For instance, it even knows at the moment, for instance, there's a lot of studies in terms of the way you write, it can predict if you're going to have an heart attack. So all of these things has implications in terms of IP, in terms of data interactivity, and as well national, international boundaries, which at the moment most of the countries don't agree with anything, much less with AI. It's not priority, at least for now. But the challenge is, okay, like I think we agree on that, is the challenge is the fragmentation of the IP legal landscape. And second, on the ownership of this, it passes through our digital savvy company is, and each of us, because one of the challenges is not just IP in terms of a company, is even our own personal IP. Because I can hack your personality, create a digital profile, and for instance, I had already people that were scammed using my profile as an influencer. Okay, so people hack my identity in Instagram and other profiles, and they went, and some people actually paid service to these people, not paid, actually paid money to them, thinking they were talking with me. Oh, and last week, just as in a bigger level, for instance, Richard Attenborough, his voice was hacked. And for instance, I can hack the voice of anyone here, anyone here. And I can create, just using a sample of your voice, I can hack you and create a digital twin of you. For instance, if you go to my YouTube channel, 40% of my YouTube channel is my digital twin, it's not me. So I have my own LLM already working. Of course, I want to not scare you, but I want everyone here to be, because you guys are the elite of Malaysia, and you have to think about this.
We need to be scared.
But there's a lot of business opportunities, by the way. All of you can create new business out of this. I want to be positive on that. And Malaysia has a huge, for instance, the Swedish, I will finish with this. You mentioned the importance of speaking international language. Malaysia, everyone speaks fantastic English. We are doing this session in English. If I would go to Dubai, probably Dubai would be in English, but most of the countries would not be in English. So this capacity of international, there's a lot of positive things as well.
Okay, so let's focus on the future, moving ahead, right? So we talked a little bit about the challenges, what's happening now, but it is moving at such a rapid pace, it almost becomes difficult to project or predict or crystal ball what will happen in the future, which makes the job of government and regulators doubly hard. How are you approaching this? The fact that this technology is moving so rapidly that you will have to future-proof the legislation, the laws, the guidelines, the rules of the game, so to speak. How do you do that?
I mean, if you look at the EU, for instance, EU have an AI Act. The key points in the AI Act is to be transparent what we are using. I mean, you are taking as someone else's work. You are taking this, and this, you combine it, put it into a creation, and put it into your invention, and you want to commercialize that invention. These things, it's clearly happened to the GitHub company in the UK. He's been sued because they're using someone else's source code, and that developer sues because you are using my source code because you're not being transparent. You want to commercialize something, but you do not acknowledge who the inventor is, and also you do not acknowledge who the author is. That's why the EU AI Act is all about. I mean, more or less, we are talking about transparency. We are talking about not to misuse the AI invention from the creators. I mean, on the government side, I mean in Malaysia, I can confirm that if you want to register for AI patented invention or AI patented or copyrighted work, you must fulfill the test. For copyright, you need to assess on the originality, whether you are actually creating that work or you just instructing AI to create their own work, and then you want to claim to register to MyIPO. I mean, logically, it is totally wrong. I mean, if you put the shoes in composers, I mean the one who are actually creating a composition of the song, and that composition of the song being used by someone else, they lose the right to remunerate because of AI. I mean, that's logically speaking, I mean, what we are looking for. At the moment, the very stage of, I mean, it's not limited to Malaysia and also globally, the law relating to the ownership, the authorship, and also the inventorship is very at infant. We are looking forward to look how the US and UK actually approach this. We are already seeing that AI cannot be an inventor or author because their lack of human authorship, for instance. But we are looking forward on the AI-assisted invention in moving forward.
Do you think there will ever come a time where AI can be recognized as an inventor or author? Is that not likely to happen? Do we determine today that it is not going to be considered an author? Dinis, do you have any thoughts?
So this is already happening. So for instance, at the moment, you can actually more or less calculate all the IP that you have just using multiple calculations. Of course, you have to be a bit savvy, but it's not completely difficult. But I think on a positive side, on that level, so I want to touch two things on, I think you mentioned a very important thing about, so the first thing is the opportunity, and the other thing is the risk. So for instance, you mentioned governments. So for instance, that's a big opportunity, and this is a provocation for Mirante, for Dr. Reis, is Malaysia can be a hub of innovation around IP in AI. For instance, Dubai created an entire business with a tiny population, a tiny place, out of just being a hub for blockchain. Miami was bankrupt after 2008, and he just created a hub of blockchain, and now is one of the most successful cities in the world, and attract massive investment. And what they did is just they create hub for bringing international players. They create a for instance, we have Lab 1 here in Malaysia. You can just create a couple of laws, putting innovation around AI and IP. That's a simple solution, and there's enough experts here to scale this. And trust me, companies like me want to go to places where I can have good food, good quality, but as well legal, attractive things. The risk is more on the cybersecurity part. So there's a consideration around IP protection, but ultimately the only people that can protect themselves is people with money, and as well with network. So let's be realistic, it's going to be incredibly more difficult than ever. And for instance, you mentioned music. For instance, Ed Sheeran, which is a global super celebrity, is using AI. Okay, it's obvious, that's why he has a lot of lawsuits. But the point, everyone is using, if you are a celebrity like that. So the risk, the one I want to highlight, and it's very important because I want to, for everyone here, is I interviewed recently a former director and spy from the FBI. And he's a very big personality in cybersecurity. And I was scared with the numbers. So the world GDP is around $100 trillion. So the cyber crime and cyber issues related mostly with what we're talking here is going to be reached, at the moment, this year is reaching $5 trillion. $5 trillion, okay? That's not a small amount, okay? And the dark web, which normally people don't speak, But the dark web, I can get data from everyone here, an IP, and copy and do whatever you want. Of course, you need to be an IT criminal to do that, but effectively, it's a $1 trillion business itself. So there's a lot of layers. The opportunities are massive, but we have to act on it. And it passes from us personal and companies like yours and ours, and as well governments, because at the end of the day, if the governments don't do this, I'll go to another government. Because I want to make sure my IP is more or less protected.
Yes.
That's the first thing I will do.
Right. Biruntha, I'm going to come to you in a second, but I just want to very quickly check with the audience. Do you have any questions? Oh, ada. Okay. Lagi? Any more? Any more? So we can see? Okay. I think there's a mic just up front. Maybe you can come to the front. Hello.
Yes, good afternoon to our distinguished panel. My name is Joseph. The question I wish to pose is with regard to image digitalization. Is there any court precedence with regard to image digitalization, especially like logos? In the past, people have been litigated and they won the cases, you see. I think in Malaysia it's a McDonald's case. But what about image digitalization? Is there any court precedence, or can it be precedence with regard to logos can be used against in suits for image digitalization? Thank you.
Syaufiq, do you want to take that one in terms of image digitalization? So I think Syaufiq mentioned the Getty case a little bit earlier, but was your question regarding whether there's been precedence in terms of use of these types of AI-generated images?
I mean, this is a very common question that when you are actually creating a work based on AI-assisted models or invention and so on. I think the key to this, because you know, in intellectual property, you cannot bend the rules of the property law. You can't actually bend the rules. You want to actually snitch, play in a hide and seek to actually create whether you can use it or not. The first thing, whether you want to create that work by using the AI-related invention, whether you are actually created by your own effort, your own judgment, and your own skills. If you just simply put into AI, hello AI, please create this image and so on, and then you want to actually commercialize that thing, put it in your website, you license it to others, that's why the GitHub is actually come into place.
If I just may follow up on that question, sometimes it's not always that cut and dry, right? It's not always, you know, hello ChatGPT or whatever AI, generative AI, create this for me. Sometimes it's more of a collaboration and the lines become very blurred. How does the law deal with that?
Okay, if you look at how the law is blurred is, if you open up a TikTok, I mean, TikTok have to pay a large sums of money to the creators. I mean, if you create a story, you want to create a music, TikTok have to pay to the creators. I mean, it is a common sense. Whenever you are using someone else's work, you have to pay. But TikTok is not actually one by one, each person to pay, each of everyone creators. They pay it as a bundles of rights. Okay? So I want to use all the musics in the world, put it into TikTok, I pay you 1 million ringgit so that I can use a license. If you take out that license from the TikTok, and then eventually there will pop up where this is not non-copyrightable
this song
things.
Cannot be used.
So on. So I mean, getting up to this question, I mean, if AI actually don't have any quantifiable amount, how to calculate those amount, just pay a sum of money because you are using a large data set, which we cannot actually determine what the data has been used because it is a bundle of rights. It is a big data, what has been mentioned. It is being scrapped, put it into a LLM. I mean, you can read all the news, even the OpenAI admitting they are using copyrighted works and also patented works of the creators, and they are still paying to the newspapers, Time, New York newspapers. I mean, as the court being directed.
Okay. Biruntha, if I may bring you in terms of practical application, right? You see this real world setting. How does it apply in the real world? Is it always kind of black and white and cut and dry? Are there nuances that we need to better understand? And how should we address those nuances going forward?
That's interesting because just to touch base on what Syaufiq mentioned, right? Yes, law is law, but there's also something called strategy. So when we are developing something, you know, let's just say we are working on a system, a development. So when I, you know, because I look at the intersection of research commercialization, and also in terms of policies and governance. So advising various stakeholders from the government side, also from the corporate side, as well as the research institutions, because that's where most of the collaborations and research outputs do come about. So what we need to understand, as creators or individuals, developers, when you're putting this in together, developing a solution, we need to basically understand, of course, as a technical person, you may not know the strategies, but you may have to work with the right technology people or the legal people to understand now, how can we now strategize the content that we are creating. So yes, like TikTok, the licensing strategy. There are various types of agreements where we can actually derive value from the trademark, the copyright, the patents that we are putting, because it's not, like I said, just a defense mechanism, but to see, okay, how can I monetize them? And what kind of licensing agreement or what kind of agreement that we should actually embed, the ownership, the authorship that's involved, what kind of agreement when we are going in terms of overseas collaboration, all right? So global expansion is our IP in any form that we are looking into. So let's just say copyright is a global protection, trademark. The brand itself that we are creating around the system, what kind of value it's going to create. So these are some of the elements that we need to look into when we put in. And from onset, from the ideation, when we are creating, there are various types of validations, and we need to understand, okay, how much or the degree of third-party sources that we are going to use, the data, the databases, because we are talking about, in the realm of AI, where software, content are all involved in. And also in terms of how can we protect the developer itself. So what kind of know-how is he translating or transferring into the system development. So very often, this is not captured in lots of organizations. So very excitedly, they develop something, and then they say, let's commercialize. But what about protecting it, the strategy in terms of protection? So it's not just protecting copyright, trademark, but also the know-how. So there are a lot of know-how in institutions, companies, the developers that we are, employing. So these are all our intellectual assets. They are not yet intellectual property, but they are assets. And how can these assets be designed and strategized in terms of protecting them, and also translating into a commercial vehicle and agreement, so that all parties, all pillars of the business can derive value. Right?
So having said all that, how do you see Malaysia institutionalizing this, all these suggestions that you said? I mean, is there a way we can integrate this into our IP framework?
Well, definitely we can, but I would say this is a very big agenda. So we got to probably start small, in steps, what I would say. I mean, I applaud the government initiatives, various government initiatives putting together and supporting our local landscape, the innovators, SMEs, even universities, the amount of funds that we are actually supporting in terms of developing innovative research in AI, deep tech, machine learning. So that's fantastic. The number of IPs that's going up, regardless patent or copyright, more on copyright, I would say, in this. So what we can do is, yes, at this moment, I think MyIPO, WIPO, they're still redefining the inventorship to see how we can work on, but it's also very important for us to start off with IP guidelines. So probably when we are looking into the digital economy or the AI initiative, I think recently under YB there's a new initiative setting up under AI. So we should look into guidelines where SMEs or business owners can look into how can they protect what kind of their business, the solutions, the systems, the different components, and what kind of mechanisms So those guidelines should be established because that's always a starting point. Of course, then coming up with interdisciplinary programs, having the right IP programs aligned with the technology side of it. So it's a marriage between the law, technology, science, and also business. So this needs to be looked into. I also advocate in terms of talent development. So yes, we really have good stuff in Malaysia, very good talent, but also developing the right set of talents. Probably the IP professionals itself should be trained and equipped with the know-how on the strategies and how to advise in terms of AI when it comes to the laws and regulatory and positioning and assisting our SMEs to now how can we do that technology transfer, the IP commercialization, and also in terms of cross-border collaborations with various international organizations. So setting that hub in Malaysia, we have all the infrastructure and facilities, bringing the talent, building the capacity, putting the policies in place, working with various stakeholders would be one. So advocating from from the research institutions, regulators, as well as programs to create that awareness is very crucial.
Well, I think we can go on and have another panel discussion to go into all the nuances that we talked about today, but we have to end it here for today. Folks, please give a big round of applause to our wonderful panelists today. Thank you so much for having us, and I'm going to hand it over back to Terence.
Thank you, Melissa, for moderating that discussion. Let's have a photograph with the panelists and our moderator to wrap up this session. Ladies and gentlemen, we do have one final panel before we take a break, so please do kindly remain seated. And a big thank you to this panel for helping us understand better the intellectual property issue in the realm of AI. Please do kindly give us your feedback via this QR code, which will flash on the screen shortly.